Thank you for joining us today to celebrate what we're calling a step in the right direction as we continue to oppose a decision made by the provincial government attempting to place a prison right here where we've gathered today. It was a decision we came to realize that had little or no consideration for a number of things. The environment, increasing loss of agricultural land, plans underway for this land by a local consortium and the municipality, no consideration for the legislation that the province themselves enacted and put in place to safeguard agricultural land, and certainly no consideration for the interests or opinions of all of us, the residents and taxpayers of Kemptville and the surrounding area, the ones that will live with it, the ones that will cover the costs like policing through our taxes, should it be built. In spite of all these obvious but seemingly avoided considerations, it really boils down to just one decision now, and it's about the legislation. And the three questions that will be posed to a panel of judges in divisional court are essentially: one, did the province abide by its own provincial policy statement? Or, as we're calling it, the PPS. And I like your enthusiasm. The answer is no. The PPS of 2020, what is it? It's a province-wide planning regulation approved by Cabinet, which has strict protections of prime agricultural land all across Ontario. All ministerial decisions must be consistent with the PPS. We're arguing that their decision to take approximately 180 acres of Class 2 farmland and build a correctional facility on it is not consistent with the safeguards set out in the policy statement as per the Planning Act. Number two, did the province have regard for the North Grenville official plan? There it is, no. The municipality of North Grenville does have an official plan and other local planning policies, and it specifically designates this land as agricultural, okay? It has nothing to do with bylaws, by the way. North Grenville's official plan sets out strict safeguards to protect prime farmland from development, and a specific policy for this site also recognizes the historical vocation of the land as an educational and research resource. All ministerial decisions must have regard for local planning policies. We are arguing this decision does not. And third, did the province consult with the North Grenville municipality? Thank you, it's getting better, I like it. The Planning Act states that the minister must consult with the local municipality before carrying out or authorizing any undertaking. We've been told many times that the province gave our mayor and our council 48 hours notice that the prison was coming to Kemptville. They have stated it publicly, that they were completely unaware, and they are willing to attest to this as well for court purposes. So it seems abundantly clear that the province did not consult before, as required by their own policy statement. The irony in all of these references to the provincial policy statement and the Planning Act is that the Act states that all ministers' decisions must be consistent with any provincial policy statement adopted by the Minister of Municipal Affairs and Housing. Everybody remember who that is. By violating these explicit obligations, the minister overstepped the authority conferred by the legislature, and so we are arguing that in divisional court that the decision to build on this proposed site is therefore illegal. For many of you who have been involved since the early days following the announcement in August of 2020, you know this has been anything but a sprint. It has been and continues to be a marathon. I think we expected that. One thing I did hear, though, is that there were people that thought the marathon would finish early, and by early, that meant the conclusion of the motion to dismiss trial that took place on March 21st earlier this year. They don't have a hope in hell, was the phrase that I heard referring to Victor and I and our legal counsel, Stefan, getting through the motion to dismiss. These people were of the opinion that it would be a slam dunk for the provincial lawyers to prove that it took too long to bring our application for judicial review, or JR as we call it, before the courts. The provincial government and their lawyers from the Solicitor General and the Attorney General of Ontario were banking on the fact that their motion to dismiss our application on the basis of timing alone would do two things. One, it would kill any chance of a legal review of the province's decision before a full panel of judges. And 2, it would use up all the money raised for legal costs and therefore eliminate any chance of us seeing this through to completion. Well, I'm happy to say they were not successful. Despite their lawyers' best effort to inundate Justice Robert Smith with information that would see him rule in their favor, on April 28th, Justice Smith rendered his decision and did the exact opposite. Not only did the province fail to convince the judge that we took too long to submit our application, they also failed to convince him that our JR application lacked merit. Their goal was to make sure that we never had our day in court, to ask the legal questions that are at the heart of this matter. We know the province failed to convince Justice Smith because rather than simply saying yes, the JR can proceed, or no, it cannot, he decisively, willingly, and impactfully said so much more. His 5-page decision made some very poignant points. A few examples I'd like to share with you. 1, Solgen only made a 1-page press release with very limited reasons for their decision. The reasons for Solgen's decision to locate the correctional facility in the town of Kemptville were never provided. Number 3, it gets better, by the way. While the proposed correctional facility complies with the local municipal bylaw, it does not conform with the official plan. Here, the town council was unaware that a correctional facility was going to be built in their town before the press release was published. And number 4, as there was no consulting as required by Solgen's provincial policy statement, in addition, it appears that Solgen did not consider or address the provisions of the provincial policy statement, which protects agricultural areas for long-term use for agricultural purposes. So constructing a jail on 178 acres of Class 2 agricultural land would not be consistent with this provision. And finally, this one's about us. The applicants have identified several arguable grounds for relief as Solgen failed to follow several provisions of the provincial policy statement. He did not need to say this. He chose to say this, and I can tell you when I said earlier, it's a step in the right direction, it's exactly that. But I would say it's a step in the right direction with a bit of a fist pump in the air as well. Believe it or not, it's been almost 3 years since the original announcement in Brockville to build the facility here. It's not easy to maintain a battle for that length of time, but we've done it. And we're ready and willing to keep doing it, by the way. We can't do it without your help and support, though. The good news, as I mentioned earlier, is that Justice Smith gave us the opportunity to test the province's actions, or lack thereof, in court. As you know, it's a process that's beyond our control, and the outcomes are never predictable, but it is with optimism and determination that we look forward to the next step in the coming months. We wanted to let you know as well that we have recently had discussions with our mayor, deputy mayor, and acting CEO, and they have confirmed their willingness to purchase all the land, all 178 acres from the province, should we be successful in our JR efforts to have the decision to build here overturned. Additionally, we have a delegation planned for an upcoming council meeting to put a number of statements of various related topics on public record. And I'd like to finally thank everyone for your support, which comes in all forms. Being able to speak to you here today in celebration of this positive step forward in our legal challenge is not something that is possible without that support and determination of many, and it makes me proud to know that we've been able to achieve the results that we have together as a community. So thank you very much for attending today.